All right, this is a PowerPoint about some of the court cases in the history of education. And I always find it important to talk about this. This really isn't part of your book, but as part of, critical and contemporary issues in education, I think it's important that as a teacher, as a future teacher, or even for those of you who are going to be in speech pathology, etc., it's important for you to understand, just some of the cases and history and legal issues that have come up over the course of time in the classroom, and what your rights are, what your students' rights are, these types of things, all the controversies that have basically happened. And especially since we just finished a unit or the module on the Dover, what was it, the Judgment Day case. Some of these things are still very much in the news, and there's still big concern in our society about what's acceptable and what isn't acceptable in the school setting. So some of the big ones. This is certainly by no means an all-encompassing view of legal issues that have affected the schools. There's so many of them, you couldn't even go into all of them. You could probably have one class on just a certain aspect of the cases, like cases that dealt with religion or something like that. But just some of the issues that come up all the time, and maybe you're aware of some of these, maybe you're not, but Engel v. Vital was a big one, and this one had to do with prayer. And up until this point, school prayer, as long as it was non-denominational, was pretty much happening all over the country in the mornings. And this particular case had to do with some I think it was some students who were Jewish, and they felt that it didn't go along with their particular faith, or I don't know the details of it as much as I should, but you could look it up. But this is important because it set the precedent. And most of the ones I'm showing you today are important because of that. In legal sense, in the legal system of our country, everything is about setting a precedent for something, and then you argue future cases based on whatever that precedent was. And this one is very important. And there have been many cases that have followed after this case about school prayer, and I'm sure there's probably some out there right now that are pending, waiting constitutional review, or something like that. Because remember, our Supreme Court, that's what they do. They establish constitutionality. When laws are made, or when state representatives or federal institutions or state institutions do things, whatever they do can then be monitored by the court, essentially. And it'll start at a lower court, it'll work its way up through the system, and eventually it could have a Supreme Court hearing. Most of them don't make it that far, but there are many. So this particular case, again, set the precedent that you cannot have school prayer in you cannot have prayer in school. All right, the Tinker case. Now, keep in mind, you're talking about United States citizens. You're talking about children, but they're still citizens. So it's kind of like, what rights do they have, and what rights do they have in the school, and what rights do they have just as being children, okay? Because remember, children don't have all the same responsibilities as an adult, so they, of course, don't have all the same privileges that would be provided to someone who's over 18, let's say. So, our society has decided that there are certain times in your life, at 16, you're eligible most of the time, sometimes 15 and a half, sometimes older in certain states to have a license, let's say, a driver's license. So the court is constantly sort of playing with the line of what is okay and what isn't okay, what are rights that students have, constitutional rights still protected, and yet how can we also make that work within a school setting? And obviously, with all of the school violence that has happened recently and in over the course of, I don't know, the last 10 years probably, but the courts are definitely having to adjust those decisions and rights, because which is more important, to keep the school safe, or to keep the individual's rights protected. And again, in our system, in our legal system, there's that constant fight: is what is the good for society versus what is the good for the individual, and how do you balance those things? So Tinker v. Des Moines in 1969 is students wanted to wear armbands to protest the war in Vietnam, and the school made them take them off, and they said it was too much of a disruption at school. And of course the kids at the time, they said, this is not a disruption, we're not saying anything. And this one set another precedent. It basically said they could wear the armbands as long as they weren't causing a palpable disruption in school. It was considered, even though it wasn't speech, it was considered pure speech. It was still protected under the Constitution, under the First Amendment. And it set the precedent. If you see in quotes there, students do not shed their constitutional rights at the schoolhouse gates. And many other court cases have come up since then, and challenging this precedent. But I will tell you that I think that a lot of things have changed over the years. Remember, all of these cases are going to reflect the court at the time. This court in 1969 was a very liberal court, and it essentially, is going to make more liberal decisions. And this decision was going to be that your constitutional rights of the individual are protected. As time has gone on, this issue, I think, is less for students. I know that in my experience, students can pretty much, think of dress codes. Students can be sent home and made to change their clothes. I had a teacher teaching at a very small town here in South Carolina, a principal who I've watched him. I want to say this was 2009-ish. I've watched him send kids home because their hair was too long. Boys, because their hair was too long. This was during the Justin Bieber phase. And, I know my mom, if it had been during, my schooling, of course I was raised in California, she would have had a fit if I was a boy and had been sent home because of long hair or something. But, it just really depends on the city you're in and what the town you're in and what they'll put up with. But certainly, could he have taken this all the way to the Supreme Court? It's possible. Anyway, so just keep in mind that there's this tension between students and their rights, their constitutional rights as citizens, versus what the school has to do in order to keep down disruptions, in order to keep the facility running properly, and all of these things. And of course, safety has become a huge issue as well. Okay, the Lemon case, Lemon v. Kurtzman. This essentially set the precedent, and you can read this later, but it set the precedent for how do we determine what is all right for states or districts to do, even the federal government. There's this excessive entanglement issue. So what does this mean? How do we say that keep that separation of church and state? How do we maintain that? So this set up what was called the Lemon Law, and it's still used today to decide future cases, to see where that line is between the separation of church and state. And what this does is it basically sets up 3 prongs of establishing whether or not whatever legal action or state action or law or rule in a school, if it's actually constitutional. So to review here really quick, in the First Amendment, there's 2 parts to establishing the religion clause, or these religion clauses, let's say. So there's the Establishment Clause, and that's the first of several pronouncements in the First Amendment, and it's Congress shall make no law respecting an establishment of religion. Okay, so that's considered the first half of the religious clause, and that's the Establishment Clause. Then there's the Free Exercise Clause, and that's, of course, continuing it on, or prohibiting the free exercise thereof. So these 2 things put together are basically what help the Supreme Court establish whether or not a state action, a school action, is considered constitutional or not. Is it infringing upon the Establishment Clause, which has to do with a religion being set, or established, again, I don't know how else to put it, established, or is it the person who is their free exercise of that religion being infringed upon? So here you'll see the Lemon Test has these 3 prongs, okay? And if any of these prongs are violated, then the government's action or the state's action, the school's action would be considered unconstitutional. So the government's action must have a secular legislative purpose. So there's the purpose prong. Number 2, the government's action must not have the primary effect of either advancing or inhibiting religion. Okay, now that's the effect prong, because these are the 3 prongs: purpose, effect, and then entanglement, and that's the last part. The government's action must not result in an excessive government entanglement with religion. Okay, so these are basically the Lemon Test. These are the 3 tests. If any part of a, if somebody said, oh, we want to have a prayer, let's say the Angle Viva Tal, wasn't established yet, but of course it is, they would say, well, it doesn't have a secular purpose. Okay, that government's action doesn't have a secular purpose. So, that's how they basically look at different acts that come up. This is one of those precedents that lawyers would always go back to and then argue in the court whether or not something that the state has done is constitutional. Remember, this is something the state has done. If children want to gather, again, out at the flagpole, they are doing this on their own. It's not given any kind of state mandate. So they're allowed to gather on their own and do this. I mean, if students want to sit and pray before they take a test, they can do that, but it can't be mandated by the state or by the government. All right. This one is about book banning. Island Trees, books in a school library that the school board deemed anti-American, anti-Christian, anti-Semitic, and just plain filthy could not be banned because they were not required reading. So, again, in 1982, I believe you're seeing there's going to be a change from a sort of a liberal court to a more conservative court during this time frame. I'm not sure that this one would stand today, but who knows? And that's the other thing to keep in mind, is that whether or not something is constitutional is really based on what the Supreme Court decides at the time, and the Supreme Court is made up of, of individuals who have their own sort of agendas and so forth, and they're appointed by different presidents who, of course, can be either conservative or liberal. So this is always going to reflect a lot of their decisions. But during this, basically, they said that school boards do not have the right, because it was the school board who was trying to ban these books, to prescribe what is orthodox in books or to remove or suppress ideas in schools. So it's okay for them to be in the library as long as they're not required reading. Now that would get into a different area. Hazelwood. All right, this had to do with, another part of the First Amendment, which of course is the freedom of the press, and in a way freedom of speech as well. And basically some students wanted to put some articles in the paper, and the principal saw them, and one of them had to do with teen pregnancy, and I think the other one had to do with an article about divorce, about these 2 parents who were going through, or this child who was going through a divorce. And essentially what it ended up saying is that, these kids, even though they're journalists, and we want to respect that, but they're really doing this as a school activity. So it gives the stamp of approval of the school, and we have the right to basically censor anything we want that's in a school paper based on that it's representing the school and not just these students' opinions or their free speech via the press. So just understand that you're seeing some rights. Remember back in Tinker, 1969, this court was much more liberal about students' rights. As we get closer to current time, you're going to find that there's a lot more restrictions on students' rights. And, this probably has to do with a lot of different things. I think obviously it has to do with safety coming closer to current days. But you'll see by 1988 that a lot of this whole freedom of speech or this freedom of expression issue and here freedom of the press, it doesn't really apply to students in schools. And then this one, I think this is the last one I chose to share with you. This is a big one, and I think it's in the works right now as a it's coming back, and I wonder what's going to happen, because I think this is probably in the next year going to be decided upon. And this has to do with the Pledge of Allegiance, and not necessarily having to say the Pledge of Allegiance, but the words under God in the Pledge of Allegiance. So does that infringe upon students' rights? Does that pass the Lemon Test? Is it part of the separation of church and state? So there's a lot of people that believe that saying under God or having under God on coins and all of that is more of it just a historical ritual. It's not really implying any particular God, or it has more historic and traditional significance. So it's not really part of the whole church and state thing. That's what one part of the argument is. And then the other argument is that it's this excessive entanglement, that under God was added during a very conservative time in our country during the 1950s, when McCarthyism and communism, of course, banned religion. So we wanted to assert in this country, we are religious, and so we're going to add this to our Pledge of Allegiance, because it didn't used to say that. And of course, students also used to pledge allegiance holding their hands up in sort of a Heil Hitler stance. But of course, after World War II, they got rid of that portion, and that's when you put your hand over your heart instead. But and of course, saying the Pledge of Allegiance in general, I think there's precedents set for that. I know that I used to have students who were Jehovah's Witnesses, and they would give me something at the beginning of the year that basically it was a pamphlet that would talk about their religion and what they believed in, and it basically said that they're not going to say the pledge. And of course, I talked to my principal about this, and this was okay, because according to their religious beliefs, they find that declaring any kind of oath they can't declare an oath to anybody but God, and therefore the Pledge of Allegiance is looked at as an oath. So they would stand at quiet attention. They wouldn't cause any, but they wouldn't actually stand up and put their hand over their heart, and they wouldn't actually say the pledge. So that's, protected. That's their religious right. But anyway, this one right here had a little bit of problem, and the Supreme Court was able to sidestep it on sort of a technicality, because a non-custodial parent, it was the girl's father who was bringing this court. He's an atheist, and he didn't want his father to have to say the pledge. But he was not her primary custody holder, so the mother didn't care. And of course, these things take years, and there's a lot of media coverage, and she just didn't want her daughter in the middle of all of that, I believe. And since basically the court knocked it down, because the guy didn't have standing. He wasn't the custodial parent. So the issue of whether or not one nation under God is constitutional was not really ruled upon. But this is, I know there's been news about this. I haven't really paid attention, but I know this is going to come back up probably pretty soon in a different court. I think somebody else has taken it up as well. So, as future teachers or future people involved in the school system in some manner, even if you are not going to be working in the school system, you perhaps will have children at some point who will have to go to schools. So this really affects everybody in our society, and just understanding some of these precedents and the ways that some of these particular things have gone is important, especially if you're going to be working in the system. And for those of you who do plan on being teachers or working in the school setting, I would definitely suggest becoming aware of what GAE or the NEA version in your state, wherever you happen to be working. There are other state organizations that are not unions, because we don't really have unions here in the South, but they have affiliations with educational organizations that will protect you if you do have a membership with them. And it's always nice to know that you have at least $1 million worth of legal fees that sort of is your insurance protecting you if you do join one of those organizations. So that's just something to keep in mind. I think in Georgia you have the GAE, which is the National Education Association affiliate, NEA affiliate. And I know I used to belong to them, and I'm not trying to promote any, because there's another one also, and I don't remember the name. It was whatever Page, I think it's called Page, Yeah, it's PAGE, Professional Association of Georgia Educators, and I know people have belonged to them as well. So, but it's just something to think about as you become a teacher, to understand your rights and to know, things that could happen. So, here's where schools and the legal system sort of intertwine, and just a little, again, a very small overview of some of the big precedents that have been set in history.